Okay, this is Corey Barrett versus Michigan Department of State, Office of the Secretary of State, docket number 20-645AL. And this is the time set for the hearing on Mr. Barrett's appeal from the decision of the Secretary of State. And would council please place their appearances on the record?
And good afternoon, Your Honor. Believe it or not, it is James Bliss on behalf of Mr. Barrett. And when the court's ready, I will proceed.
Yes, and then for the Secretary of State?
Elizabeth Allen on behalf of the Secretary of State and the people, Your Honor. Thank you.
Thank you. Go ahead then, Mr. Bliss.
Thank you, Your Honor. I'm aware of the standard of review in this matter, and this appeal is brought pursuant to MCL 2573234A, and we are focusing on two parts of that statute, subsection 4, which is that the decision of the hearing officer was not supported by competent material and substantial evidence on the whole record. And then on subsection 5, that his decision was arbitrary, capricious, and clearly an abuse or unwanted exercise of discretion. And to that end, Your Honor, I want to start with just defining a couple of cases or a couple of phrases because they become important to this argument. And one is the substantial evidence, which I will be talking about. And substantial evidence is that which a reasonable mind would accept as adequate to support a decision, being more than a scintillae, but less than a preponderance of the evidence. And I found that in Van de Zat versus State Employees Retirement System, which was 266 Mishap. That's at 579. That's a 2005 case, but I also found it again in a case called May versus Secretary of State, which is an unpublished opinion, number 346687, which is April of last year. So, and then the other one as a decision is a definition that I pulled from a case called Goolsby versus Detroit, which is a 419 Mich 651. It's an 84 case where the court noted on page 678, that the generally accepted meaning of the term arbitrary means it's determined by whim or caprice or arrived at through an exercise of will or caprice without consideration or adjustment with reference to principal circumstances and significance, decisive but unresponsive. And this becomes important in this case because this is it. The hearing officer's whole decision, his opinion, 38 words. And it reads as follows. It's so short I can just read it. And it's, petitioner failed to present sufficient corroboration of when he last used alcohol and or marijuana. Moreover, he failed to become involved in AA as recommended in his substance use evaluation. As such, the threat of relapse is much too great. That was it. Despite all the evidence which is attached to the transcript that was at that hearing, including the information contained in the original petition, he didn't mention any of that at all. We presented well, let me say this. The testimony preserved in the transcript is that Mr. Barrett admitted that he last used alcohol in November of 2018. That is consistent with his petition for the hearing. It is also consistent with the substance abuse evaluation with Ms. Bazo, which is attached to the transcript and is all part of the record. The only thing that he couldn't remember in the course of that hearing was when in November that he had last used alcohol. A lot of time had gone by. So a fair reading of the record clearly illustrates that he did present sufficient corroboration of when he last used alcohol. He presented as evidence not 3, but 7 letters, which were incorporated into the record. Not one indicates that he still drinks alcohol, but all of which indicate he's doing well, has a great work record, and exhibits the type of conduct that we would expect from someone who is not drinking alcohol. His employer, and there were 2 letters from his employer, stated that he has talent, he's excellent at his craft, no indication that there's any alcohol problems. And Mr. Barrett had testified that because of his inability to drive, he's being greatly prejudiced from moving forward in his craft and has been for years. His father, who was a respected attorney in this community, testified that he has not seen his son drink in something like 4 years, and he sees his son all the time. So our main argument is the hearing officer failed to balance the facts. He gave no consideration to the time which had lapsed in this case. And I did a lot of research, Your Honor, and none of the cases that I was able to find involved any case where you had 12 years between the time of the last alcohol conviction and a request to drive. It's been 12 years since 2009. Not only has he not been in any criminal trouble at all, and when he was drinking, he would get into trouble. That's pretty clear. He's not been in trouble. He's never, he hasn't violated the order of the Secretary of State and driven an automobile and pulled over. So he's done his part. They gave no consideration to the fact that Mr. Barrett was drinking and the trouble he was getting in at the time and how he's different now. He did not consider the opinion of the alcohol expert, nor, as I read, did he comment on it. The opinion of the alcohol expert, which is Judy Basel. In this case, I tried to recommend the best alcohol assessment person I could in this area. And it was her expert opinion that Mr. Barrett was in substantial full remission and that prognosis was good, which she said is the best recommendation that she gives. Nothing in her testing caused her to indicate that he was less than honest or supported another conclusion. Yet the hearing officer never mentions that report. And I think the time frame becomes important here when we talk about the prejudice and we talk about the arbitrariness of this particular short decision, because the alcohol evaluation by Ms. Bazo was dated December of 2019. So the actual interview was before that date. I want to say it was quite a while before the date, weeks. The drug and alcohol drop was done in November 2019. She asked him to go over and drop. He did. It was clean. That record is part of the record and is attached to the transcript. The letters covered the period from November, December, and January of 2020. The actual request for hearing was January 20th, and the hearing wasn't granted until July the 10th, which is 6 months later. So even though we started this process and we had at that point 10 years, really, a little over 10 years gap between the last time he got in trouble and the time that we petitioned the court, we ended up going much further. So the whole thing start to finish took about 9 months. I mention that again because he had no violation of the Secretary of State's order during that period. The period of suspension itself prejudices this petitioner appellant because the law, dulls memory and recognition. It's very, when the hearing officers get their petitioners before them, they question them on little details that for years ago. And I would submit to the court that would not go over in a court of law. If you had a criminal case where the evidence was and the testimony is 12 years old, I'm not sure the court would admit it because it's awful difficult to, bring somebody's memory back. I can't remember what I did last year, let alone 12 years ago. So I think he was really prejudiced by that. I think that goes to the arbitrariness of this very short decision. And so, and just in conclusion, the failing of the hearing officer to balance all the facts presented at the hearing or to even address them in the decision makes his decision very arbitrary and capricious. Mr. Barrett presented substantial evidence that the hearing officer did not consider, that he did not weigh, and that he did not report. Importantly, the hearing officer did not consider the time or the petitioner's conduct in the past 12 years. He did not comment on the testimony of the witnesses or on the testimony of the substance abuse evaluator, nor did he comment on the clean record or any of the positive things that had happened in the last 2 years. He did not comment on not driving. He did not even comment on the prejudice that we presented testimony of this, to the prejudice to this particular appellant that he has had to undergo for 12 years by not being able to drive. He can't improve his craft because he can't drive. And, he hasn't been out there driving like some people do. So he's trying to do the right thing. The bottom line is, additionally, the hearing officer will say, well, we'll see in a year. So you come back in a year, great expense, by the way. Every time they do it, it's about $1,500 by the time you get it all together. You come back, you do that in a year. And if he doesn't like what he hears, it'll be another year. I don't think it was the intent of the legislature that the Secretary of State hearing officers would be able to ad infinitum deny somebody the privilege of driving. And that is essentially what happens in this particular county, that's for sure. So this court has the power and ability to find that the decision of the hearing officer was arbitrary and capricious. The substantial evidence, there was substantial evidence presented that he did not consider. And if you would like a citation, substantial evidence is that which a reasonable mind would accept as adequate to support a decision. Again, that was in the Van Zant case I mentioned it earlier. And clearly that didn't occur here. The other thing, Your Honor, is I remember back in my law clerk days, there was a statute on circuit court jurisdiction that said that the circuit court judges has, under their powers of equity, the ability to make a decision, even if that ability goes against the statute, if the court finds that it's unjust. And I would submit that that's unjust here. I could not find that statute, or I would cite it to you, but I know I used it many times. So I would ask the court to grant him a license if the court feels it's appropriate, a restricted license he could drive like he would normally do with the boot on his car or the alcohol attachment, and rule in our favor.
All right, thank you. Ms. Allen?
Thank you, Your Honor. And the people fully understand the petitioner's position, and I'm sympathetic to it, but on behalf of the Secretary of State, there's a burden that the petitioner has to meet in his initial presentation and pursuant to very specific rules, which unfortunately, that's what the hearing officer laid out. From the record in the order, it appears they denied the request for several reasons. First, specifically in regards to the letters, the hearing officer said that they did not address the defendant's use of controlled substances and failed to present sufficient proof as to when he last used alcohol or marijuana. And the hearing officer did reference that evaluation by Ms. Bazo, and he said the evaluation recommended petitioner attend AA twice a week and work with a sponsor or mentor, and the petitioner did not offer evidence he was complying with this. And so now we have a standard for this court to apply, and that's whether his substantial rights have been prejudiced as laid out in the statute. And looking through those standards as laid out, I think the hearing officer did explain why the license was not granted. And the Secretary of State would say that those reasons in the statute to overturn that decision have not been met. Thank you.
All right, thank you. I can assure you of a couple of things, and one is that I cannot overturn a decision from the Secretary of State just because I think it might be unjust, even if I really believed it was unjust. That's exactly not the law and not the standard. I have to stay in my lane. My lane is I'm doing appellate review of this. And as Mr. Bliss has accurately stated, two of the standards by which I review this are at issue here, whether there's competent material and substantial evidence, or whether the decision was arbitrary and capricious, or capricious. And that is my standard of review. It is not to second guess what the Secretary of State hearing officer did. It's not to substitute my judgment for that of the hearing officer. If I did that, that's what Mr. Bliss is suggesting, that I would look at this and say, well, this is unjust, and undo it. But that would be exactly what I cannot do, because that would be substituting my judgment for that of the hearing officer. And I cannot by law do that. And I cannot properly perform my function as a circuit judge reviewing this if I were to do that. So again, it's not whether I think it's just wrong or whether I would have decided something different, or whether I think this is unfair or that enough time really has gone by. I have to review it according to the law. The hearing officer has to do the same thing. And the hearing officer has to work within the promulgated rules. And those have the same force of law as a statute. And the hearing officer here was working with the promulgated rules that say that the petitioner has to establish that his substance abuse problems are under control and likely to remain under control, and has to show a period of complete and continuous abstinence as set forth in another rule. And another rule says exactly how that is done. And these are rules that everyone knows going into the hearing, that this is what they have to meet. So the other rule says that in order to meet that burden, you have to have at least 3 independent sources to corroborate the petitioner's behavior with respect to alcohol and controlled substances. The evidence may consist of statements from witnesses who personally testify or from testimonial letters. They should be from people who are most likely to know a petitioner's alcohol and or drug use habits. So the only 2 witnesses who testified live at the hearing were the petitioner and his father. That's fine, and that's certainly valuable. The letters that are referred to in the rule, or the other testimony that was referred to in the rule, were submitted by way of letters, also fine. And the hearing officer looked at those letters and considered them. I did too, because I always am suspect that someone has misread something or misrepresented something or omitted something. And I always carefully look at the letters as well, because the hearing officer had a lot of criticisms of them. I reviewed the letters, and the hearing officer is correct in what he or she, I don't know, wrote. And that is that Mr. Beard, his father, wrote, and his letter and testimony was fine. But he said that the petitioner hadn't used drugs or alcohol in over 4 years. Okay, so there's one letter, but there were 3 other letters from, I'll just say, Jeanette, Joshua, and Kathleen that didn't address at all when it was that he last used alcohol or illicit drugs. And then another letter from Nate wrote that the petitioner was alcohol-free, but again, I reviewed the letter and the hearing officer is correct. It doesn't say as of when. And then Mary wrote that the petitioner hasn't had a drink with her in her presence in many years. And then his brother, Scott, he said that petitioner had been sober for well over a year, but the letter and the hearing officer wrote this, and it's correct. The letter didn't have a date. It was unclear when the sober date had started. So I checked all those things out, and the hearing officer was accurate in his assessment on those. And then speaking of assessments, with regard to the substance abuse evaluation, it's just not true that the hearing officer didn't consider it. He didn't address, well, no, I strike that. He did address the fact that it made a conclusion that he was in full sustained remission based on the length of abstinence, and that he was given a good prognosis for continued abstinence. It says that right in the hearing officer's findings, and that would be on page 2, paragraph 1, 2, 3, 4. So he did address that. But then he also noted that the recommendation from the evaluation was that the petitioner attend AA twice a week and work with a sponsor and or mentor. And the hearing officer noted that the petitioner offered no evidence that he was complying with that. So the hearing officer did follow the law. followed the promulgated rules, it's not for me to say I disagree or I would have given Mr. Barrett a license back, because he seems fine to me and safe, and seems like he's doing what he's supposed to do. That's not the standard. The hearing officer followed the law. The hearing officer considered the evidence. The hearing officer applied the evidence that was submitted to the law, including the promulgated rules. And I cannot say that the hearing officer's conclusion was not based on competent material and substantial evidence. And I certainly can't say it was arbitrary or capricious. So for those reasons, I am denying the appeal and dismissing the appeal. And I will need an order that says that.
Well, thank you for your consideration, Your Honor.
Thank you. And that will conclude this hearing.